Good afternoon, everybody. Thank you all for taking up your valuable time, lunch hours, to attend this afternoon's Vincent's fortnightly presentation. My name is Nick Combis. I'm one of the directors in Insolvency and Reconstruction. And this afternoon, I'm going to touch on some insolvency-related matters. Specifically, I want to talk about some developments that are occurring in insolvency or proposed developments, as well as touch on what is happening with the Australian Taxation Office and its collection process. So the usual disclaimer, obviously the information provided is general in nature, and any party who's got further requests, queries, specific issues should raise those directly either with me through the chat line, contact myself, or seek professional advice as appropriate. I will point out at this afternoon's webinar, the chat function is live, so I would welcome any questions, queries, issues that people wish to raise this afternoon. I propose just to quickly touch on a number of matters which have been proposed. Obviously the items are listed there, so this whole issue of 1-year bankruptcies, which has been floating around for a while, how trusts are treated in insolvency related matters, specifically in corporate matters. So the use of trusts by individuals to operate businesses has become much larger over the last 10 to 20 years, and the insolvency laws certainly need to catch up in that regard. I'll briefly discuss the safe harbour provisions, improving schemes of arrangement, and the old bugbear for creditors is the unfair preference claims. So we'll speak about that. Some of the things ASIC are doing regarding assetless administration and funding for creditors is there. And finally, I'll touch on the ATO, its director penalty notices, as well as some sundry issues. Recent events. So the last 2 years have probably seen more changes and proposed changes, some permanent and some temporary, due to the COVID-19 pandemic. I think we're all pretty much sick to death of hearing about it, and I think we need to move forward now and get back to what was pre-COVID terminology and try to put the whole COVID thing behind us. However, what COVID did actually do was assist in fast-tracking significant changes in insolvency legislation. There were also significant temporary changes, and all those temporary measures have pretty much run out now. To give you an example of some temporary measures and now some modifications to make permanent, prior to COVID, you only needed a debt of $2,000 to place a company into liquidation, and you needed a debt of $5,000 to bankrupt an individual. During COVID, those two amounts were increased to $20,000, so substantial increases. Those increases were only temporary. They have run out. However, there has been adjustments and modifications. That's actually a typographical error. It should actually be $5,000 with respect to liquidating a company now. Oh no, I think it is $4,000, sorry. And $10,000 to bankrupt an individual. So the amount to liquidate a company has doubled from $2,000 to $4,000, and the amount to bankrupt an individual now is permanently $10,000, up from $5,000. One other great measure is obviously the use of electronic communication. Previously, that was extremely difficult to do in insolvency related matters. However, now with the temporary, now permanent measures, insolvency practitioners are able to hold virtual meetings of creditors, able to use video recordings, able to issue most communications, not quite all, but almost all communications electronically. And also another raft of changes which occurred right in the midst of the COVID pandemic was the small business turnaround, restructuring, and the simplified liquidation process. So what is all that about? The small business restructuring was there mainly for entities that had debts of less than $1 million. They were viable they were viable companies, and all they needed was some restructuring. One of the big keys about the small business restructuring was it was a director in possession. In other words, the administrator or the liquidator in that case does not take control of the company. He does not trade the company. He does not have personal liability. So the same management is still in control. There's a moratorium put on the debts. There's some reporting to creditors, proposals made, and if accepted, then the company is able to continue ongoing as it was prior to, and the administrator of the restructuring process will deal with the unsecured creditors as per the agreement reached. The simplified liquidation is meant to be a low-cost insolvency, where obviously a company could not exist. It allowed for or provided for limited investigations. I don't believe the simplified liquidation process has been very successful, and for a number of reasons, particularly I think the thresholds that the small business restructuring and has not been a major success either. So what has been proposed and what does the future hold? Firstly, I'll touch on 1-year bankruptcies. There was a proposal approximately 5 years ago by the Attorney General's office, and there was a discussion paper seeking feedback on reducing the current standard term of bankruptcy from 3 years to 1 year. It is in line with what happens in a number of jurisdictions overseas. The UK, I believe, have a 1-year bankruptcy, Canada as well. And some people have considered the 3-year bankruptcy to be harsh and draconian. Proposal was originally raised in 2007. It got quite a lot of press and energy at the time. However, for a number of reasons, elections, wars, etc., it lost priority. It was brought up again in 2001 and most recently again raised this year. What are the benefits of a reduced term and why is a reduced term considered appropriate? The greater majority of personal insolvencies in Australia are non-business related. They are, I suppose, what's considered to be the mums and dads, people who may have overextended on some credit cards, some personal loans, and really have limited or no assets. And that is probably 90% plus of all bankruptcies in Australia. They pretty much have no assets, no realizations, no investigations or significant investigations necessary. And for that reason, it seemed draconian that those people would do a 3-year term of bankruptcy. So by reducing the term to 1, it's considered a more equitable balance to the whole personal insolvency system. Against that, of course, are the ones who are the less forthright bankrupts, the ones that require more investigation. And there were obviously certain submissions which say no, the term should not be reduced because that time is needed by a trustee in bankruptcy in order to investigate. Also reducing the term releases that stigma, allows for things like overseas travel, potentially being able to be a director of a corporate entity, though it's yet to see what ASIC's view is. Their initial view was they still wanted a person who has been bankrupt, even though discharged, perhaps after 1 year if the changes go ahead, still be prohibited from being a director of a corporate entity for 3 years as it currently stands. There is no final legislation. There is no draft legislation at this stage. It is a proposal. I believe it's one that's had bipartisan support from the major parties. Given the change of government, it's a wait and see whether this will be, and these other insolvency reforms I will touch on, will be high up on their agenda. To assist those who are repeat offenders, to assist in the trustees being able to properly investigate. There are a number of exclusions which will prohibit people from being eligible for early discharge. So if they've previously been a bankrupt, if they've been banned previously by ASIC from acting as a company director, have an objection to their discharge file due to perhaps lack of compliance, possible offences, etc., or been convicted of certain fraud-related offences. So there are safeguards for trustees and other stakeholders. If they believe a bankrupt administration should be extended, they certainly will have that ability and capability. Treatment of trusts. This is a really difficult and complicated area. People might think it's quite straightforward, but in reality, in an insolvency sense, it can be quite difficult, complicated, and it does require great care. So the situation can arise where you have a company acting as trustee of a trust. Now, there could be one of two things happening. The company could be trading in its own capacity, and that situation is pretty straightforward to deal with. However, where you've got the company acting as trustee of a trust and the business is operated through the trust, then there is no clear position on how that is currently dealt with in a corporate insolvency related matter. Because the assets are the property of the trust is not a legal entity. It does not exist on its own without the benefit of a trustee. The trustee can be an individual or it can be a corporate entity. If we discuss the corporate entity side of things, when that entity goes into liquidation, the only rights a liquidator has is a right of indemnity against the assets of the trust. How does he enforce that right of indemnity? Well, currently that external administrator must apply to court to either be appointed a receiver over the trust assets or an order from the court which permits it to secure the assets of the trust for the benefit of the creditors that the trustee company incurred on behalf of the trust. That makes it complicated. If, however, you've also got the company acting as trustee of a trust, which is trading, and it might do some other things on its own and incur its own liabilities, then the liabilities it incurs doing its own thing, not acting as trustee of the trust, cannot attach to the assets of the trust. So you can see in some larger corporate entities, complicated group structures, there are lots of idiosyncrasies that need to be dealt with. Perhaps to further complicate matters is you have a situation where most trustees say where there's an insolvency event by the trustee, for argument's sake, an individual going into bankruptcy, a company either going into administration, receivership, or having a liquidator appointed, then that company can no longer act as trustee and it leaves the company as bare trustee. And it's up to the appointers of the trust to appoint a new trustee to deal with the trust. So you can see there's lots of layers of complexity. There are the occasional trust deeds, and we have seen those where there is actually, it does not exclude the trustee from acting in a insolvency event. So you need to get hold of a trustee. You need to make sure that as a liquidator or as any external appointee over an entity which acted as trustee, you are aware of your rights, duties, and obligation. So what's happened? So the government's issued a consultation paper, obviously seeking to clarify a number of issues. So when does a trust be taken to be insolvent? And what role does then an external administrator of a trustee take when the trust becomes insolvent? We also need to deal with how trust assets and liabilities are administered, as well as the order of priority. Under the Corporations Act, the order of priorities give certain priorities to employee entitlements. Under the trust law, all creditors, regardless of what they are treated equally. There is no priority for employees. Again, in order to interfere with that, you need to get an order of the court. So, and obviously we want to discuss and get some clarity around, is a trustee automatically removed simply because the clause is in the trust deed? Or if the trustee is not removed, can the trustee who's insolvent, who's in liquidation or bankruptcy in the case of an individual, continue and secure those assets without a court order? Consultation process closed late December. No further word at this stage from the Inspector General. Given, however, that there has been a change in government, one is probably not hopeful and optimistic that there will be much movement in this front in the near term. So obviously the issues which we previously touched on was accessing the assets of the trust. How do you secure them? In the legislation, there needs to be some definition of a trust and when it is insolvent, bearing in mind a trust is not currently a legal entity for legal purposes. You don't sue a trust directly. You've got to sue the trustee on behalf of the trust. We want to obviously keep the cost down for the external administrator by reducing the necessity to have to go to court. An interesting one is, should there only be one company always acting as trustee of a trust, as opposed to perhaps 2 or 3 corporate entities being trustees of a trust? All stakeholders need to have better education on how to deal with trusts and what their legal obligations and liabilities are. And obviously we've got to discuss what those potential impacts are on other stakeholders, such as beneficiaries, other trust creditors. All those need to be weighed in before any raft of changes does enter. In its recent budget in March, the government obviously pledged significant funds in order to progress these reforms. Whether that will still be taken up by the Labor Party, given that it has committed to everything in the coalition budget, we are again hopeful it will proceed, but perhaps not optimistic it will proceed perhaps as quickly as it may have done. Let's quickly touch on some safe harbour provisions. What basically safe harbour was, and it's another recent raft of changes, and to break it down in simple terms was, it's to absolve a director from insolvent trading damages where that person has taken and sought appropriate advice at an early stage, has indicated and made a declaration that the company is currently in inverted commas safe harbour, and has also ensured, in order to qualify for safe harbour, you must ensure that all your taxation lodgements and obligations are also up to date. When the legislation was initially introduced, I believe one of the, possibly the Greens even, it may have been, indicated that it wished a review after a few years in order to see how the process was working and whether there needed to be any amendments. And I believe that's certainly a good thing in any new legislation. So just to touch on safe harbour, so it's obviously absolving a person's liability for debts incurred whilst the company is stress-inducing. Introduced in 2017, obviously the reviews have taken a bit longer due to COVID, etc. And obviously what we want to do is to carve out the risk for insolvent trading. So we want to encourage these directors so they can be innovative and entrepreneurial in their ability to seek solutions to turn around a business which might otherwise not survive if they were concerned about insolvent trading and immediately appointed an external administrator. So I believe they certainly are good provisions. They have been used somewhat by larger listed type companies. And those companies, of course, have to report such things to the Australian Stock Exchange via the appropriate releases. So there certainly is some benefit in the safe harbour provisions. Obviously, these reviews are good because I think there can be some fine tuning to make them more accessible to the SME market, the small to medium enterprises. So I certainly believe that safe harbour will be updated, will be modified, will be fine tuned, and I believe it's a good piece of legislation. So as you can see, consultation closed late last year. And what some of the feedback was and obtained is a lack of understanding in the market in general. And obviously we want to alleviate that stigma associated with being in safe harbour. It did concern directors because they were concerned how it would look to their customers. So through education, through a better understanding, clients and customers will understand that it is not a terminal event being in safe harbour, and I can still somewhat safely continue to trade and operate with that organisation and work with it in order to achieve an outcome to the benefit of all stakeholders. Some creditors in their feedback indicated that the safe harbour provisions unfairly prejudiced them in favour of the directors, and they basically raise that because of the inability to take that insolvent trading action. I don't believe that's totally well founded, but it certainly does take away a right they previously had before. And we also need to understand that if a director is relying on certain material to establish safe harbour, unless that is produced, he cannot then rely upon that defence. So again, it just puts some further pressure on the director to be forthright, honest and forthcoming when going through such a process. And again, that can only be a very good thing also. Oops. Not sure what's happened there. Sorry. There we go. Sorry about that. My screen went all blue for a second. So some further issues, obviously. How will illegal phoenixing operate on the safe harbour regime? Phoenixing, again, is not a word that's described in any legislation. However, what it's meant to effectively mean is where we have a company that shuts down on a Friday, a new company opens up on the Monday, operates effectively the same business, utilising the same staff, pretty much the same assets, commonly a very similar name also. There are obviously two kinds of phoenixing. You have the illegal, which is an intentional process to defeat creditors. And then you have the legal phoenix, which is a legal restructure where it's done through a professional. There's appropriate valuation of assets. There's appropriate consideration paid. And assets can either be marketed publicly or as long as they are sold for fair price or the fair highest available market price at the time, then obviously it is a legal process because we are not intentionally leaving creditors behind. We are not intentionally structuring to be in this position. It's due to circumstances, a bad debt, a COVID situation even, whereby we're in this position through no direct fault of our own. We've taken active steps at an early stage and we've done the process with the appropriate advice. Obviously, ASIC needs to indicate how it wishes safe harbour provisions to operate in practice and issue some directives as well. The government did collate all the information. There was a final report and recommendations which went to it on the 24th of March. And again, the government pledged almost $1 million in order for these reforms to go ahead. Quickly touch on schemes of arrangement. They are a restructuring process, and again, it's regulated under Part 5.1, which is the most of the corporate insolvency provisions in the Corporations Act. It's there to assist financially distressed but solvent companies to restructure in order to avoid any form of external administration. It is a useful tool though not widely used, because it is a court-driven process. So the schemes of arrangement generally only occur for the larger entities that have the funds in order to drive that court-driven process. It's a binding agreement between the company and its creditors, allows the company to continue trading while varying its debts and the certain claims, and sometimes even priorities between certain creditors and other stakeholders. Obviously, that's a process where the government's seeking feedback regarding moratoriums for the creditor's claim and the ability to enforce those during the scheme formation. So the moratorium protects against any creditor actions and allows these companies that might be financially distressed temporarily some breathing space in order to formulate the process. Not mentioned here, but obviously trying to simplify the process, make it less court-driven process and keep the costs down is obviously another issue there. So the consultation closed late September. There's been no further movement that I have seen since that time. Let's touch on the unfair preference claims. And I will just remind people, anytime chat function is open, you certainly can continue to or bring things up as need be. The unfair preference claims is a real bugbear of many creditors. So the unfair preference claim is where a liquidator is able to claw back from a creditor of a company that received a payment prior to its insolvency, a payment it received. As I spell out there, where creditors get a preference, priority, or advantage to one or more of the other creditors. So if a company has 10 creditors, it chooses to pay one creditor in full, doesn't pay the other 9, and then goes into liquidation. Obviously, that one creditor that did get paid has received a preference, priority, and advantage over all other creditors. Thus, the liquidator can claw that money back and distribute it ratably across all creditors. Obviously, what tends to happen, sadly, is invariably most insolvencies are not well funded, and those funds are utilised in the first instance to be distributed towards an insolvency practitioner's remuneration. Then, because of the way the order of priorities fall, then go to employee entitlements, and then there's finally monies available for unsecured creditors. So many of these preference payments recovered, creditors do not realise any money. The unsecured creditors, I should say, do not realise any funds. There are similar provisions in the Bankruptcy Act 1966. Obviously, the creditors who are better, more diligent, more proactive in recovering their debts argue, why should I be punished because I'm good at collecting my debts, where those who are slack at collecting their debts simply could benefit from me having to pay back my money. And when I do pay back my money, I know that creditors aren't going to see any of that anyway. So it is a very difficult provision for an insolvency practitioner. And obviously, decisions made to pursue preference payments are not taken lightly. They're not taken without a thorough investigation. Commerciality is obviously considered as well. And obviously, the liquidator needs to prove that creditor received a preference, priority, or advantage over other creditors, and it received its payment at the time when the company was insolvent or became insolvent because of that payment. So what is the government seeking to do in its submissions and in its inquiries? Well, obviously, we want to simplify the rules for creditors. So those creditors who act honestly and in arm's length cannot be pursued if the transaction is under $30,000. Currently, there is no threshold. So that's a big bonus. And secondly, or the payment is made more than 3 months from the date of external administration prior to the company, 3 months effectively before the date of liquidation. Currently, that period is 6 months. So you can see the period is being halved, where a liquidator can recover anything going back 6 months. Now you can only recover only more than 3 months back. That's from the date of liquidation, prior to obviously entering into liquidation. So the proposed changes were considered along with the simplified, which commenced on 1 January 2021. So they do exist in the simplified process. They don't currently reside in ordinary liquidations, or as we know them, the typical liquidation. Government's pledged significant funds in the recent budget again for these reforms. So you can see in the last budget, there's been substantial funds put forward to progress these. And obviously we are hopeful they will be progressed. Another one, which is, I think, a really good measure is the issue of assetless administrations, which in reality are assetless liquidations. So in effect, what they are is where a company has little or no assets when it enters into liquidation. The greater majority of insolvency appointments taken by liquidators are either very little assets or no assets. In that case, a liquidator does not get paid. He does not have recourse to any fidelity fund or other pool of funds currently in order to undertake appropriate investigations and reporting. So what the Assetless Administration Fund was established is in order to allow a preliminary investigation and reporting by liquidators to be undertaken in situations where a company is considered assetless. Currently, we can apply for grants of up to $5,000 where an administration is assetless. It is a modest sum, and it is argued that in order to undertake even a basic simple liquidation, the cost would need to be somewhere between $10,000 and $15,000. Obviously, the fund can also be utilised for more detailed investigation and, where appropriate, recovery action also. So the Asset Administration Fund is a good proposition, and we certainly favour it. Obviously, we'd like the amount to increase slightly. I will now quickly touch on the issue of the Australian Taxation Office and director penalty notices. So over the last couple of years, the Australian Taxation Office has been somewhat accommodating of many taxpayers in the pursuit of outstanding liabilities. It obviously was another stakeholder, and a substantial stakeholder, in the ability of many corporate entities and individuals avoiding an insolvency event. And it certainly contributed greatly. It withheld substantial action. It gave significant payment arrangements. It bent over backwards in order to assist many taxpayers. And in my view, rightly so. However, it needs to be understood that the Australian Taxation Office is an independent arm of government. It is not controlled by the government of the day. It is a separate bureaucracy, and it is there for the benefit of all Australians. So it has an obligation to obviously collect revenue, which then goes into consolidated revenue, which the government then utilise in order to meet its obligations, its promises, its budgeted promises. Prior to give you an example of the efforts the ATO went to, prior to COVID, the Deputy Commissioner was the largest petitioner of companies in liquidation and applicant of placing individuals into personal bankruptcy. During that period of time, it liquidated very few companies, and obviously the ones it did were very topical. They were matters that were in the public interest. They were of significant, substantial concern to the Australian Taxation Office. So there's been this hiatus for significant period of time by the Deputy Commissioner, the Australian Taxation Office, in going after. There's now we are seeing the end of COVID, and with a bit of luck, we don't have to mention that again, and we are trying to get back to business as usual. So what has happened since then? Well, probably over the last 4 or 5 years, we've seen the level of outstanding debt due to be collected by the ATO increased significantly, somewhere upwards of 30, even potentially as high as 40%. So there's over $60 billion or thereabouts sitting out there which needs to be collected. So at the end of March of this year, the Australian Taxation Office begun business as usual. It issued almost 30,000 awareness letters for disclosure of tax-related debts to directors and other individuals. The Australian Taxation Office has two functions. The first function is compliance. It wants you to ensure you complete your BAS forms, ensure you complete all your statutory lodgements, so it knows what the outstanding debt is. Its second function is then to collect that debt. If you don't notify it of the debt, it doesn't know what the debt is. But does that help me? No, because the Commissioner then will just issue a just estimate of what it believes the debt is, generally higher than what it is in reality, and start pursuing you for the debt. So if you're compliant, the Commissioner will work with you with respect to the second arm, which is collection, if you're having financial difficulty. But burying your head in the sand and doing nothing will not help you. And it also issued 52,000 awareness letters regarding the ability for it to use director penalty notices, where obviously you've got directors who are either not communicating with it, not doing lodgements on time, or doing lodgements on time but then perhaps not communicating regarding payment of the obligation. So you can see that the Commissioner has issued a significant number of letters in order to proceed, in order to commence its process of collection. Now, out of issuing all those notices and letters, it received at least 30 to 40% immediate contact, feedback, and communication, which is what it wanted. That's what it wants. Initially, it wants communication, dialogue, and compliance. And after it gets that, then it can work with you, all being well, in order to seek repayment of that debt. So what is this director penalty notice? And I'm sure lots of people have heard it. Obviously, it is quite a draconian piece so it's a draconian tool that the Commissioner has in order to pursue and recover debts. So it gives a director 21 days from receipt in order to take certain steps or else face personal liability for the debt of a company. And the debt could either be a GST debt, a PAYG debt, or even a superannuation guarantee charge debt. So it really puts the onus on a director to take immediate action. The time frame is very short and cannot be extended. So you need to act very, very quickly. The DPN is not the first tool the ATO would use in a recovery process. It is one of the last tools. So if you get a DPN, it's generally because you failed to report, you failed to communicate, or you failed to make payment when you said perhaps you would, or failed to communicate about making a payment obligation that is currently outstanding. So I strongly urge anybody who has received a director penalty notice or who may have received a warning notice to read it carefully, seek appropriate advice where you can, and act quickly. Do not just pile it in the bin. Do not just disregard it. I cannot emphasize enough the importance of dealing with it quickly. I'll also point out that the director penalty notice is not issued to the registered office of the company. It is issued to the personal residential address as per the ASIC records of any director or directors who were a director of the company at the time the obligation was incurred. What do you do to avoid personal liability? Obviously, you pay the debt. You could put the company into liquidation, appoint a voluntary administrator, or even undertake a small business restructuring practitioner to go through a small business restructuring process. As indicated, the ATO in the whole during the pandemic was very supportive of any formal restructuring process, whether it be a corporate deed of company arrangement, etc., whether it be a Part 10 or even other scheme entered into by an individual in order to have their bankruptcy annulled. It appreciated the financial struggle and difficulties facing many, many businesses. However, the increase in director penalty notice and warning notices obviously now signals that the ATO has come to a point where it believes that any business and individual has had an opportunity to get its affairs in order, and now it's back to normal and it's back to the usual process of dealing with creditors in the usual fashion. And the light touch approach it did once have is now gone, and it is business as usual. Interestingly, well, earlier this month, the ATO issued a media release, and it doesn't do this very often regarding its collection processes. At this media release, or written within it, was the ATO acknowledging that it expects the number of insolvencies to occur over the coming month as the economy begins to normalise. And those insolvencies will be driven partly by it getting back into doing part of what it would do, and it would liquidate companies, and it would unfortunately bankrupt individuals who hadn't come to an arrangement to pay outstanding indebtedness. And as you can see in that quote there, and it's I think a really important quote, our debt collection activities prioritise those taxpayers representing higher risks and refusing to engage. That is why our initial focus will be on the taxpayers with higher debts initially, also including those with other debts. Taxpayers who have superannuation guarantee debts will also be prioritised and targeted, irregardless of their debt level. And that is because the superannuation guarantee is an entitlement that's owed to the employees. It's not a payment to the commissioner, though the commissioner does have the power to collect outstanding superannuation amounts where they've not been remitted to the respective funds by the due date. So all I ask is everybody certainly be well aware. They're also seeking against those taxpayers, like I've indicated, who aren't responding or engaging. So the ATO has also issued nearly 300 intent to disclose notices, and it's commenced disclosing some of that to credit reporting bureaus such as Equifax and Creditor Watch. So that's another step that the ATO will start to utilise a lot more, which it has not done so in the past, is reporting recalcitrant payers in order to these credit bureaus. And that will obviously cause significant issues for any business trying to continue and be viable. And really importantly is the ATO indicated in the press release, we are currently issuing 30 to 40 director penalty notices each and every day, and expects that number to increase. So you can see that its collections processes are certainly ramping up. The ATO continues to pursue. It will certainly be more aggressive, and there will be a rise in insolvencies. Obviously, like with anything, there needs to be some balance and equilibrium between saving any business that's viable versus those which are simply floundering, flatlining, and not contributing to the economy, and simply just continuing to incur debts which it has no prospect of ever paying. It is rare the ATO would know whether a company has that ability to be viable or not. So where a company does suffer financial distress, where an individual is having difficulty meeting its obligations, it is important to seek appropriate advice before it becomes insurmountable, in order to see what restructure can be put in place, what measures can be put in place in order to manage those debts, in order to avoid any insolvency debt obligation, and in order to be able to continue in the ordinary course. I will quickly touch on some sundry matters before I end up, and we should be able to finish within the hour, so that should hopefully please everybody. One of the issues which has been topical, and the Attorney General has sought some stakeholder feedback, is the detection and the eradicating of untrustworthy advisors. So they are untrustworthy pre-insolvency advisors is the terminology they use. I will point out that pre-insolvency advice is not illegal if it is honest, if it complies with all legislations, if it does not facilitate phoenixing. It certainly is a valid tool to be utilised by people. What they are trying to seek out, and I will point out that registered practitioners such as myself and many others do provide that advice to perhaps clients of our firms, to provide that advice to other third parties, where we don't end up, and we cannot then act as any insolvency practitioner if we have given the pre-insolvency advice. So that would prohibit us from acting, which also allows the market, which allows creditors and stakeholders to have that faith and confidence in any appointed external administrator that he or she is independent. He has not given pre-insolvency advice. But obviously the Inspector General is seeking to stamp out those what they consider to be the untrustworthy advisors. They are few and far between. Sadly, like probably in every industry, in any industry, there are probably a few apples in the barrel that do unfortunately tend to be rotten, and they do tarnish all the good, honest operators out there. So what are we trying to do? Obviously, and what has been done in the consultation paper, a new measure is put in place, is that anybody wishing to declare themselves voluntary bankrupt, they must now disclose whether they received any pre-insolvency advice, and if so, from whom. They do oblige bankruptcy trustees to make inquiries regarding any pre-insolvency advice, and to provide that information to the regulator also in the case of any court-appointed bankruptcies. Stricter or perhaps more workable offences to make it an offence for an advisor or anybody, actually should be albeit, any person to commit or attempt to commit any offence under the Bankruptcy Act. In other words, if you try to hide an asset, if you try to assist an individual in intentionally defeating creditors by putting assets beyond the reach of a trustee or making it far more difficult in frustrating a trustee from recovering those assets, those offences will now be available far easier and certainly far harsher. There was a consultation process entered into, closed on February of this year, and we are certainly awaiting the next step. As I previously indicated, there were some temporary measures also introduced during the COVID period. They've effectively all been wound back now, and it's business as usual. But it is important to note some of those measures, which were temporary at the time, have become permanent. Issues of obviously electronic communication and electronic means to conduct meetings of creditors, streamlining creditor meeting processes through voting slips, etc., has made it far, far easier than what it used to be. What has also obviously occurred for many industries, and it's certainly not lost on the insolvency profession, is the temporary and alternate working arrangements, where you have staff either working remotely, working from home, alternate hours as well. Obviously a big issue for many organisations during COVID. And what we've found, which is probably not unlike most industries, are that the much more flexible working arrangements are also being factored into insolvency engagements and insolvency staff and insolvency industry. So what we find as a profession is we have staff choosing to work remotely from time to time, perhaps choosing alternative work hours in order to assist them with children in the mornings, with after school care in the afternoon, with other types of things. So what I will just ask is that if you do send somebody an email and they don't respond necessarily straight away, be somewhat mindful that there are people who do now work on these alternate hours, just perhaps like in your industry as well. And all practitioners are very cognizant, I believe, of that, and they get back to all stakeholders and requests for information quickly. But that is a development that certainly is a work in progress for everybody, and we'll all find out shortly what our equilibrium will be. So just finally to wrap up, and again, thank you everybody for your attendance this afternoon. Some points I will leave you with. And if you haven't gotten much out of this afternoon, I do wish you to certainly take at least these points out. There's a raft of legislation and a raft of proposed legislation. Some of it will go ahead hopefully quickly, some may not go ahead so quickly. It's important to be aware of what's there on the horizon, particularly if you're advising clients, you're in business, and you need to understand what may or may not affect you in business going forward. I'm not sure what the current focus of the new government will be, whether it sees some, none, or all of these measures as being high up on its agenda. But they are certainly there, and I'm sure there'll be plenty of people agitating that some of these recommendations and processes do proceed. Don't bury your head in the sand. Where you're being pursued by the Australian Taxation Office, don't throw away the correspondence. Don't fail to communicate. Don't fail to undertake your obligations in order to complete your lodgements. Be a compliant corporate or individual citizen with the ATO, and you will find the ATO will work with you and will do as much as it can in order for you to alleviate an insolvency event and, of course, to pay off your indebtedness to the ATO. It's obviously very difficult when you don't lodge 5 or 6 BASs and then lodge them all at once, and you have this significant debt in the many hundreds of thousands, and then try to negotiate a repayment arrangement with the ATO. You need to be communicating and lodging on a timely fashion. And finally, if you do find yourself in any situation where you get a document from the Australian Taxation Office that you don't understand, that you're not sure of its implication, if you are what you believe to be risk of insolvency, if you are having pressure paying your debts, if you are having difficulty meeting your obligations, you're not sure if your company or your business is viable, please seek timely expert advice. It doesn't always have to be from an insolvency practitioner such as myself, but what I do stress is you seek that timely expert advice who can hopefully give you recommendations, advise you of your obligations, and assist you with any measures that can be taken in order to perhaps salvage what something might otherwise not be salvageable. It's important to also understand, simply because you approach an insolvency practitioner does not mean it's terminal for the entity, the business, or the company. We also certainly do reconstruction, where we can certainly assist and facilitate. We can do turnarounds of businesses if we're approached at an early enough stage where the entity is not too far gone. So I'll just leave you with those few points. And again, thank everybody for their time this afternoon. If there's a topic or a matter you wish Vincent to discuss for you, it does not have to be insolvency related. We certainly have many strings to our bow here. We certainly do forensic, litigation support, taxation, superannuation, finance. We can certainly present on a raft of measures. So if there's any particular issue you wish to raise or any particular topic you would believe you would like to hear, please send in an email, let us know, and we'll certainly attend to that. Finally, I believe the slides are also going to be circularized. You'll be able to contact me either through our website or through the slides, I hope. If there are any questions or issues, I will ask that you finally put those in the chat site. I would like to think that I've answered all questions, or everyone's fully understood and absorbed everything I've said this afternoon, and therefore there are no questions. That being the case, I'd love to again wish you all a wonderful and enjoyable afternoon, and thank you for your attendance.